Welcome. I'm Peter Afrasiabi, host of the Curious Lawyer series. The Curious Lawyer is a really fun walk down a different path of law to where you may normally go. It's not your standard core practice area or tips and tricks on how to do a better cross-examination or write a better deal document. This is just for fun, educational, entertaining, and a time to look at a different area of the law, sort of off the beaten path for lawyers. And so if you're a curious lawyer, which I know you are, you want to follow our series. We've looked at dog law and how the legal regime regulates dogs. We've looked at space law, CIA law, you name it. They're fun, whimsical, off the beaten paths for you as your lawyer. So today, we have a fun one, crazy weird laws. Today we're going to be looking at a variety of just simply crazy weird laws that are on the books across the country that regulate our lives and the lives of our clients. And this is sort of one of those fun walks down the insane side of the legal system. So let's get going. You can see what we're going to be looking at today because, again, this is an educational program. It's not just entertainment and fun, although it is that. Educationally, we're going to be looking at a variety of different legal regimes, federal, state, local regimes, with a substantive overview of many legal areas. We're going to brush up a little bit on some criminal law, tort law, family law, regulatory regime. We're even going to talk about patent law a little bit. Substantively, sort of subject matter-wise in the areas, we're going to look at a little sports law. We're going to see some internet law, some voting-related laws, and really everything even in between. And we're even going to cover, you know it, flatulent cows. Now, one thing we're also going to look at, obviously, is human sexual relations, because so many of our legal regimes, strange laws and laws, seem to be obsessed historically and even today with regulating all manner of human sexual behavior. So we're going to be looking at sex laws too. And finally, we're going to look at even some, Sixth Amendment, constitutional, citizenry, jurisdiction laws that, stay tuned for the end here, may have created a lawless zone in Yellowstone National Park, little corner of Yellowstone where you can do whatever you want and have no federal criminal prosecution. Don't trust me though, because I don't want to be blamed if you go there and get in trouble. But it's a strange look at the crazy legal regimes that exist. Now, some of the root questions that we are going to ask as we walk through these crazy weird laws are constitutional questions, and it's a running theme. Are these laws constitutional? And, why are they on the books? If they were on the books from long ago and they're not constitutional or they're improper, why are they still on the books? Why haven't legislatures and, our elected officials fixed it and got rid of them? And one of the questions that we will ask ourselves, of course, is, are some of these crazy laws, these really weird laws that at first blush seem insane and silly and stupid and, you name it. We've all said it, we've all seen it, we've all read press about it. But are they really, or may there actually be some rationale that sits beneath the law that actually makes what at first blush looks crazy, not so crazy? So that's our fun, curious lawyer exercise for today. So let's get going as we look at the first area, and this is where family law meets criminal law. And we're starting with cheating spouses and the roller coaster of the law when it comes to cheating spouses. Now, let's start with Michigan Penal Code. This is section 750.30 of the Michigan Penal Code, titled adultery. And subsection 30 of this is the punishment for adultery. Any person who shall commit adultery shall be guilty of a felony. And when the crime is committed between a married woman and a man who is unmarried, the man shall be guilty of adultery and liable to the same punishment. What's the punishment for the cheating spouse and even for the unmarried person who's with the cheating spouse? The punishment is a maximum of 4 years in prison and a $5,000 fine. And if a married man sleeps with a single woman, or vice versa, even the unmarried party is subject to prosecution. Now, there are not a lot of prosecutions under this law, obviously. I couldn't find any. But many states do have laws like this on the books. And these laws are sometimes vestiges of the past, but they're on the books. And they can be used to prescribe and punish behavior. Californians, if you're in California, you're lucky. There's no such law like that here. But let's keep going on this roller coaster. The question we ask is such a law constitutional? I mean, can a state legislature really say that one adult cannot have sexual relations with another adult just because one of them is married? They raise, of course, questions about the right of privacy and the right to engage in extramarital sex? And is there such a right to engage in extramarital sex? Now, here's what's interesting. Some of these adultery laws, where there have been prosecutions, so don't think you can never get prosecuted, you could in certain states. Some of these adultery laws do survive rational basis review given the state's interest in protecting family units and preventing disease. And those have been rationales where courts have adopted and said, yeah, I guess the law is constitutional. And we're going to look right now at this one from Utah. And this is a case called Oliverson versus West Valley City. It comes out of the District of Utah in 1995. And it's not a criminal prosecution, but it's a situation where a police officer, an employee, was fired from his job as being a policeman because he was found to have engaged in adultery. And so he was unhappy and he filed a constitutional challenge saying, you don't have the right to fire me for adultery. So let's go to the next slide and see what the Utah district judge held. And here's the quote. These employments of the criminal law to punish the practice of adultery support the conclusion that a wide variety of cultures and judicial systems have found adulterous conduct sufficiently injurious to justify some form of sanction and to be conduct which society was not only unwilling to approve, but to attach an opprobrious criminal statute. The American experience is somewhat different, but historically there is even greater support for the criminalization of adulterous behavior. In 1991, the criminal penalty in the adultery statute was reduced from Class A misdemeanor to Class B misdemeanor. In 1971, the gender differentiation that discriminated against married men was eliminated. Any married person who has sexual intercourse with anyone other than that person's spouse is guilty of adultery. And so what the court then said is that fundamentally, to declare adultery a constitutional right, the court believed would be a significant change in the constitutional doctrine of the law, and it could actually be read to then to support the right to engage in polygamy. And so the court rejected the idea that the Constitution gives the plaintiff here an unfettered right simply as a married man to have sexual intercourse outside of his marital relationship, and it rejected such a broad right of privacy. Now, it cited to Bowers v. Hardwick, the seminal case from the 1980s that rejected the right of privacy in private homosexual sexual relations, and it relied on the Bowers case. Now, we can also look at this case from the Fifth Circuit in 2017 called Coker versus Whittington. There, the court concluded that the Constitution, again, was not violated where two sheriff's deputies were fired for moving in with each other's wives before finalizing divorces from their current wives. And if you can't get the line straight of who's living with who and whatnot, just keep reading, don't worry about it. The court ultimately concluded that the sheriff's policies were supported by a rational basis. And so the two sheriffs who, I guess, swapped spouses and moved in with them before they'd finalized their divorces could be fired without violating the Constitution because their behavior was adulterous and the law had a rational basis for supporting that. And again, another case, 10th Circuit 2008, upholds similarly termination of officers. Like, what's going on with officers? You got to stop and pause and ask. All the cases are police officers getting fired for this. Who knew? In any event, this case, coming out of the 10th Circuit in 2008, again, upheld the termination of an officer on the basis of an extramarital affair under the rational basis test because there's no fundamental liberty interest to engage in a private act of consensual sex. So those are some holdings you see coming from the 5th Circuit, the 10th Circuit, and Utah on this roller coaster ride. And you're at the bottom of the roller coaster ride there if you live in any of those states. But let's take this roller coaster up, and on our next slide, we're going to California. And this is California from the 9th Circuit. The Lawrence case from the U.S. Supreme Court, as you may all remember from your con law and from recent years, abrogated the Bowers v. Hardwick decision. And so Lawrence makes clear that the state may not stigmatize private sexual conduct simply because the majority traditionally viewed a particular practice, such as extramarital sex, as immoral. And so the 9th Circuit started from that proposition and came to the opposite conclusion. And here again, it's another police officer case. The police department fired a police officer, and he argued that, well, you fired me because of my adultery that you were unhappy about. And the 9th Circuit concluded that if that was true, the firing then would violate the officer's constitutional rights unless the adultery negatively affected on-the-job performance or violates some constitutionally permissible, narrowly tailored regulation. And that's a similar test to firings based on other constitutional rights, such as free speech and the like. So in any event, in the 9th Circuit, different standard, and that's the Perez versus City of Roseville case. And that case was decided in 2017 by Judges Reinhart and Tashima and visiting District Judge Malloy. Now, the roller coaster continues on our next slide. Even if you have a right to cheat, even if you're in a state where you actually can cheat and you can't be sent to jail and you have the constitutional right to engage in extramarital sexual relations, you can still be sued by the unhappy spouse for alienation of affection. And here we can look at North Carolina, and this is true in many state common laws. North Carolina, Malekek versus Williams, and this is from the appellate court there in 2017. And you can see here the quote from the case. This case concerns two common law causes of action, alien of affection and criminal conversation, that permit litigants to sue the lovers of their unfaithful spouses. These laws were born out of misogyny and in modern times are often used as tools for enterprising divorce lawyers seeking leverage over the other side. The roller coaster continues. Now, let's take the roller coaster on the next loop, because now we're going around the military turn. What if you're in the military? Well, as of 2019, the Uniform Code of Military Justice, Article 134, was updated. And it was updated to make clear that adultery remains, because it had been on the books, an extramarital sexual contact that can be prescribed, and that it can lead to punishment and discharge. And the Uniform Code of Military Justice provided that adultery included genital, oral, and anal acts. But the Code of Military Justice also provides it's not considered adultery if you are legally separated, and that was a relaxation of the prior law. So, where are we on this first step down our Curious Lawyer series in terms of crazy weird laws? We've got this conflux of a whole bunch of different laws from legal regimes that say there may be a constitutional right to extramarital sex depending upon where you live, but there may not be such a constitutional right if you're living in a different jurisdiction in America. And if you're in the military, not so much a right unless you're separated, in which case maybe you actually do have a right, but you need to be separated. And of course, in all states, you could be sued by the unhappy spouse for alienation of affection, and in North Carolina for even some other torts. So it's a confusing hodgepodge of legal regimes that come out to different places on what is, in the 21st century, a really interesting question. Because is there really not a right to engage in extramarital sexual affairs? Can you really be sent to jail for it or fired for it? Turns out you can, and it kind of depends upon the circumstances. And that's the question that the Curious Lawyer asks you to think about yourself. Where should the laws be on that? Because that's something that you can take up with your legislators. So let's now move from cheaters to fortune tellers. And this is going to take us to a continuation of our constitutional law discussion. And now we're going from California, Utah, and whatnot. We're going back east to Massachusetts. Massachusetts has a law related to fortune tellers. And the law requires that to be a fortune teller in Massachusetts, you have to be certified. And you can only be certified if you've been in Massachusetts for 1 year. You need a residency requirement, a 1-year residency requirement. This is Massachusetts General Law, Chapter 140, Section 1581. Now just stop and ask yourself, this is crazy, right? What is the rationale for this law? I mean, is it really a fear that traveling fortune tellers who don't reside in the community may lie about your fortune when you pay them for the fortune? But if they're a resident there, they're not lying. They're really getting the fortune about your future correct. Hard to believe, but who knows? In any event, one of the questions that's come up with this is this constitutional? Apparently, a traveling fortune teller was quite unhappy and believed that there should not be such a residency requirement, and this is unconstitutional. This went to Talamo versus Providence Board of Selectmen in the District of Massachusetts, and it was found to have concluded that it actually was unconstitutional. So now we've got the situation where you just can't make this stuff up. Fortune tellers taking your money to tell you your future, it's unconstitutional to pass certain laws restricting what they can do. Yet on the other hand, it's completely constitutional to get another form of cheaters, and that is, spousal cheaters, fired or go to prison in other states. So cheaters to fortune tellers, crazy weird laws. Let's keep going. We're now sticking with constitutional law, but we're pivoting a little bit. We're pivoting to voting. And we're going to go start with Texas. And this is the Texas Constitution, Article 1, Section 4. It states religious tests. No religious test shall ever be required as a qualification to any office or public trust in this state, nor shall anyone be excluded from holding office on account of his religious sentiments, provided he acknowledge the existence of a supreme being. The question we're going to look at is, does this raise First Amendment issues? Now, before we get to the First Amendment issues, let's just stop with and take a look textually at this language, because it's a little bit crazy, I think. It's almost circular. I mean, we've highlighted there in red for you. I mean, the Constitution itself actually says no religious test shall be required. That's a pretty aggressive, firm statement. No religious test, provided you acknowledge the existence of a supreme being, which seems to undo the idea of the establishment of a religious test and have established some form of a religious test, or at least some form of a theistic test in terms of belief in a supreme being. It's hard to really harmonize those two statements we have there in red. And then we can add to it the obvious absurdity about the use of only male gender in there in terms of, he must acknowledge the existence of a supreme being. I don't know if the intent was that women running for office don't have to, or more likely the idea that when this law was passed and was put on the books, women weren't even allowed to run for office conceivably. That could be how old this law is. But in any event, the law has been taken before the legislature to be revised, and people have complained about it, but it remains in the Texas Constitution, notwithstanding desires to change it, to this day. So let's ask the question, since it has remained on the books of Texas. Does this violate the First Amendment? And we're not talking about the circular language in there and the gender language, just the straight up substantive question. Can you have any kind of a religious litmus test to demand that someone run for public office or be allowed to run for public office and hold public office? Turns out, we'll see in the next case, Torcaso versus Watkins, the Supreme Court has looked at this and analyzed it. They did so a long time ago, 1961. You see there in the case site, 367 U.S. 488. So this case involves Roy Torcaso, and he was appointed to the office of Notary Public by the governor of Maryland. Now, he couldn't receive his commission to be Notary Public for Maryland to serve because he was unwilling to declare his belief in God, and the Maryland Constitution required him to declare that belief. So he couldn't get his notary commission, even though he was appointed to it, and so he sued. And he sued in the Maryland Circuit Court on grounds that the requirement that he profess his belief in God violated his First and 14th Amendment rights. This went to the Maryland Circuit Court, and they said, nope, you have to swear it or you don't get to be notary public. And then it went up to the Court of Appeals of the state of Maryland, the highest court, and the Court of Appeals of the state of Maryland also affirmed. This then led to a petition brought by Mr. Torcaso to the United States Supreme Court. And the question that was squarely framed by his petition is whether a state requirement that a candidate for public office profess a belief in God in order to be eligible, whether that violates the First Amendment protection of the freedom of religion. And the answer, you can see here on our slide from the United States Supreme Court, was that it does violate the First Amendment. So let's take a look at this. The court said, there is and can be no dispute about the purpose or effect of the Maryland Declaration of Rights requirement before us. It sets up a religious test which was designed to and, if valid, does bar every person who refuses to declare a belief in God from holding a public, quote, office or profit of trust in Maryland. We repeat and again reaffirm that neither a state nor the federal government can constitutionally force a person to profess a belief or disbelief in any religion. Neither can constitutionally pass laws or impose requirements which aid all religions as against non-believers, and neither can aid those beliefs based on a belief in the existence of God as against those religions founded on different beliefs. And so that decision from the U.S. Supreme Court was unanimous, 9-0, authored by Justice Black. And in light of that, it's pretty clear the Texas constitutional provision is unconstitutional, which raises the question that we asked throughout a series of looking at these crazy laws. How can a law that's facially unconstitutional, since 1961, this is now 60 years later at least, how can that law remain on the books? Well, perhaps it remains on the books because it's never enforced, no one cares, and no one even knows it's on the books. It's just some buried law in a code book, right? But that's not true with the Texas law, because there have been a lot of movements to remove that from the Constitution, but it hasn't been removed. That gets to one of the questions we're looking at, which is, why do we have these laws, and why don't our legislators comport the law to the Constitution and remove this ambiguity and uncertainty, which just spawns further litigation, problem, expense, legal fees, and the like. Now, let's meander down our crazy weird laws, Curious Lawyer program, and we're going to shift now to the internet. In our internet slide here, we're looking at Tennessee. And in Tennessee, it's criminal to share a subscription-based online password and use someone else's password on Netflix, Hulu, Disney Plus, or any other internet subscription sites, even if a friend gave it to you. So let's stop and look at this law. This comes from the Tennessee Code, section 39-14-104A, and this is the general criminal provision about theft. And it says, a person commits theft of services who intentionally obtains services by deception, fraud, coercion, forgery, false statements, false pretense, or any other means to avoid payment for the services. And the key here is in section 106, subsection 35. It was amended in 2011 to augment the definition of the word services. And services was expressly amended to include entertainment, subscription services, or other public services. So you have a situation where a person commits theft of services if they intentionally obtain entertainment subscription services passwords. And the punishment is up to $2,500 and up to 1 year in jail. Now, if it was $500 or less of entertainment value, it would be a misdemeanor punishable by up to a year and a fine of $2,500. That's a pretty big deal. Now, I'm not aware of any criminal prosecutions yet, but what I do know is when I travel to Tennessee, I'm not sharing my Netflix password with my daughter. Now we'll go to sports. And you see there a famous picture. Mike Tyson biting off the ear of Evander Holyfield in a fight. Now, what does this have to do with sports regulation? I guess apparently that bite was not a one-off situation. I had no idea, but apparently boxing may be plagued by biting boxers biting other boxers. Who knew? Because the Utah Athletic Commission, their act in Chapter 10, Part 1, 63N-10-102, subsection 22, actually says there is no biting allowed in boxing. Now, this is in this slide deck for this reason. How absurd is it that we've reached the point that a legislative body, a regulatory body, needs to enact a law, an ordinance that makes clear that to all the members who participate in their sport, you cannot bite. I mean, this is boxing after all. You'd think that if one boxer bit another boxer, the umpire would just deal with it and call the fight and issue a punishment or whatever. The idea that it actually has to be positively legislated and prescribed as unlawful behavior at some level starts highlighting the point that many of these slides get to, which is crazy weird laws sometimes percolate to the surface because of this overregulation of every aspect of life. You'd think you don't need a law to tell a boxer that you can't bite someone, and you'd think you don't need a law in order to reach a punishment for it. But in any event, the no biting law is on the books. Now we're shifting, as we get a little more into this odyssey on plain crazy stuff, we're going to shift back to California. And we're going to go to a case where someone was arrested and a criminal prosecution was begun for, yep, you nailed it, trimming plants. And so this situation involves a guy in Ocean Beach, California in December 2013, Vince Adame. And Vince Adame was trimming some shrubs, and these were New Zealand Christmas brushes. And they were in the yard west of him, and it was a sort of a haven for homeless people in the back alley, and the bushes were large and whatnot, and they were growing over into his yard. And so he cut them, and the bushes were just sort of wild bushes growing in this alley, and he trimmed the bushes. And it was a place where homeless people were taking refuge for the night, and they were making a mess in the area, and it was city property, and the city refused to clean it up, despite his requests, apparently. So in any event, he trimmed those trees. Someone was unhappy, and someone from the city came down and arrested him for felony vandalism of city property. defacement, damage, and destruction of public property valued at $400 or more. His response was, I was trimming a bush overhanging my property, something the average citizen does all the time and should do, and where are you cleaning up the alley? Now that's an example of a crazy, crazy use of vandalism law, right? And the charges were later dropped after a public outcry in the news media about it, and he was, defiant and refused to back down. That's an example of perhaps not a law that as facially written is plain crazy. I mean, obviously you need vandalism laws that prohibit vandalism, but it's an example of crazy, weird laws as used by prosecutors and those with discretion, arresting officers, to trip people up in the criminal justice system. And so while it's great the charges were dropped, who knows how much money was spent on legal fees by Mr. Adame to get out of that crazy, weird situation. And we're going to stay in California, and we're going to go to Laguna Beach, California, and the Pacific Coast Highway. Is it plain crazy or is it not? It's for you to decide. California, and we're talking about loud cars on the Pacific Coast Highway. Now, the Pacific Coast Highway, of course, is an iconic highway in California, and it's part of, California, legend and lore and myth. It's the Pacific Coast Highway that's cars have cruised up and down, top down, cruising in your Mustang convertible, seeing the beach, the Harleys cruising up and down. Well, it turns out that iconic highway and those muscle cars and motorcycles have irritated certain legislators. And here in Laguna Beach, there's a local law that has prohibited anything above 80 decibels. Now, what's interesting is the California state law says 95 decibels is the limit, and if you go above 95, it could be a nuisance. The interplay of state and local laws is such that the city felt comfortable saying, well, we can also prohibit anything above 80 as being a nuisance on the Pacific Coast Highway. And it turns out the Pacific Coast Highway cuts through the city of Laguna Beach. And so since January of 2020, there have been over 1,600 exhaust tickets issued against that most American of pastimes, cruising muscle cars and cruising Harley Davidsons down the PCH. Plain crazy, plain weird, you decide. But it's certainly an example of regulations that may well conflict with state laws, where you have this hodgepodge patchwork kind of quilt-like regime of laws, each regulating different aspects of human behavior, and frustrated local officials who don't like loud cars, even though we know they love all the traffic and the tax dollars it brings to the community. Now let's go back to Massachusetts, going back east again, and we're going to talk about plain crazy again. And here we have a law on the books that has not been taken off the books, and it's a law, Massachusetts General Law, Title I, Chapter 272, Section 36, Crimes Against Chastity, Morality, Decency, and Good Order. And this one deals with blasphemy. Whoever willfully blasphemes the holy name of God by denying, cursing, or contemptuously reproaching God, his creation, government, or final judging of the world, or by cursing or contemptuously reproaching Jesus Christ or the Holy Ghost, or by cursing or reproaching or exposing to contempt and ridicule the holy word of God contained in the Holy Scriptures, shall be punished by imprisonment in jail for not more than 1 year, or by a fine of not more than $300, and may also be bound to good behavior. Now, I call this the OMG law. You see there a little picture of the OMG emoji, and OMG has sort of entered the lexicon of speech. Anyone and everyone uses it. In fact, I suspect you could find some Massachusetts legislatures who have issued out a Twitter tweet or an Instagram post or a Facebook post using OMG or the emoji, of course, of which is pre-populated in your phones by cell companies and phone companies and the like. And so this is an example of a law that remains on the book, but actually, I guess, makes it unlawful to issue that emoji or use that phrase. This, of course, gets to the question of freedom of speech. And here we will take a pause again to go back to the First Amendment of the Constitution about whether Congress, and of course the states, because the First Amendment, as you remember from con law, the states are subjected to it also via the 14th Amendment, whether these laws can stand on the books and whether they should be on the books or whether they should be cleaned up and the books should be made to mesh with the state of the law of the world we live in. And so here's the First Amendment to the United States Constitution. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. And the question we're really getting at as we look at these crazy, weird laws are, where are the legislators? I mean, where are they at this point? Especially when you think about the fact that they're using the phrases, everyone's using the phrases, it's on all TV and radio all the time, right or wrong, and I'm certainly not taking an opinion or professing a belief about that. Everyone's entitled to their own beliefs. It's just the point that this is happening in common vernacular all the time, and it's reached the point that it's even become an emoji on phones. It's sort of time, I would think, in Massachusetts. In Massachusetts, I could do part 2 on a lot of their laws that are still on the books. We could do, version 2 of this program in the future, and maybe we will. But they need almost a version of what Justinian did 1,500 years ago when he sat down and looked at the 500 years of common law of, the ancient Roman Republic and Empire and said, my goodness, we need to clean this up. And he commissioned all the, the lawyers and the judges of the time to gather up all the laws, codify them all into one book. He stripped out the ones that didn't make any sense anymore and set the playing field, reset it so that they could all work off the same baseline. That was 500 years into sort of Roman law. Time for Massachusetts probably to take a play from Justinian and do that, I think. Now we're going to shift again, and we're going to go to Alabama, and we're going to talk now about sex toys. And we're talking about laws criminalizing the possession of sex toys. Are these laws plain crazy? Now, this is a nuanced question. In this plain crazy, weird law seminar that we're talking about here today, I'm not so much raising the question of whether prohibitions on sex toys themselves are crazy. I leave that to you to decide. Everyone can have a different opinion on it. What's particularly fascinating about these laws that we're going to see is the interrelation of the legal regimes and how we've reached the point that we can have a situation where some states say you can't have any, some say you can have a certain number, and meanwhile the federal government's saying the complete opposite in terms of areas of law that it regulates, and that's what's plain crazy. So, personally, I kind of think consensual adults, what they do in their bedrooms with sex toys should be up to them, but like I said, I leave that to you to decide. That's not why we're attacking and focusing in here on Alabama and the other states we're about to talk about. So let's take a look at Alabama's law. This is the Anti-Obscenity Act of 1998. So no, it's not a law that goes back hundreds of years, part of ancient morality. It's a new law. And it says, quote, "It's unlawful for any person to knowingly distribute, possess with intent to distribute, or offer or agree to distribute any obscene material or any device designed or marketed as useful primarily for the stimulation of human genital organs for anything of pecuniary value." It's Alabama Criminal Code 13A-12-200.2. Now, let's keep going because let's look at more of the law. The law also says, any person who violates this subsection shall be guilty of a misdemeanor and, upon conviction, shall be punished by a fine of not more than $10,000 and may also be imprisoned in the county jail or sentenced to hard labor for the county for not more than 1 year. Any person who violates this subsection shall be guilty of a misdemeanor and upon conviction shall be punished by a fine of not more than $10,000 and may be imprisoned in the county jail or sentenced to hard labor of the county for not more than 1 year. The question we have to ask is this constitutional? Now, one district court held that no, this is not constitutional. It went up to the appellate court. The appellate court reversed actually and said it is constitutional. And the Supreme Court refused to take the case. So as it stands, not only was this law passed in 1998 and challenged and found by some judges to be okay and others not, the Supreme Court refused to intervene, and so the law stands on the books. So you may ask, and this is not legal advice, but I know from what I have read and researched in Alabama, what goes on in order for companies involved in the business perhaps of selling adult sex toys? And there's a loophole in the law for medical or educational purposes. And I think reading between the lines, and again, this is not legal advice, so don't give your Alabama clients this legal advice. It strikes me that people are finding ways to claim medical and educational needs for these products to get around the law. Now, is that plain crazy? That's for you to decide. But let's go to Texas. Texas is a little similar, but it's a little bit different. Texas says it's illegal to have more than 6. That's Texas Penal Code section 42.23. A person who possesses 6 or more, not 5, not 4, 6 or more obscene devices or identical or similar obscene articles is presumed to possess them with the intent to promote the same. And per Texas law, a vibrator is deemed an obscene device, and that's the Villarreal versus State case at 267 Southwest 3rd, 204, page 206 in 2008. And so the result is having more than 6 means you're presumed to be engaged in some unlawful intent to promote the same and sell and do something else that violates the law. But if you have 5 or less, I suppose it's presumed for personal use and it's okay. So already you can see this massive discord in terms of, yikes, just traveling between Alabama and Texas could be rife for risk for people. But here's where it gets really crazy, and this is the craziness. Alabama, you can't have them. You can go to jail, unless it's for medical or educational purposes. Texas, you can have 5, but not 6. But check out what the feds say about this. The federal government will give you a patent on sex toys. Yes, you heard it here, a patent on sex toys. And let's do a quick refresher on patent law so you can understand why that is. Federal patent law says that the government will issue patents for all useful, novel, non-obvious inventions. And that's from 35 U.S.C. section 103. So the result is that federal patent examiners, upon the request of inventors, have issued patents for a whole bunch of sex toys. We have a list of some of them here. Self-remotely controllable wireless sex toy. And you can see there in the parentheses, that's the patent number or application number, and you can look it up if you want online yourself. Their patents have been issued for self-lubricating sex aids, for an oscillating intercourse simulator, and for a talking vibrator even. That's U.S. patent number 5928170. Now, I didn't show the pictures of them, but you can find them on Google. This is a PG presentation, so I figured I'd leave those pictures out. But these sex devices, which are illegal in some states, they're actually deemed useful devices by the federal government worthy of patent protection, which can only be given to new, useful, non-obvious devices. So while the feds say vibrators can be useful, certain states say it's illegal to have one. That's a crazy hodgepodge legal regime. So let's now move, since we're in the realm of sex, to some other sex laws. Public restraints. We're in Florida now. Married couples cannot engage in openly lewd or lascivious behavior. That's Florida Criminal Statute section 798.02. And here's the statute. If any man or woman, married or unmarried, engages in open and gross lewdness and lascivious behavior, they shall be guilty of a misdemeanor of the second degree, punishable as provided in 775.082 or 775.083. Now, I couldn't find any recent prosecutions, at least in the last half of the 20th century, but South Beach and Florida are popular locations, so I wouldn't get carried away on spring break in South Beach because you never know what law you could trip. And since we're in the realm of sex, let's now pivot back from Florida all the way back to California. And this brings us to cross-dressing laws and the City of Walnut, California's Local Code 17-31. You need sheriff permission for a man to dress as a woman. And here's the statute, the ordinance that's in effect, and I last checked it January 2021. But here's the ordinance. No man or boy shall dress as a girl or woman without a permit from the sheriff, except for the purpose of amusement, show, or drama. Now, this on its face raises multiple constitutional issues, obviously. I mean, you have equal protection questions, gender questions triggering intermediate scrutiny. I mean, men can't cross-dress, but women can. And then gender aside, you've got this very question about personal sexual identity and just human dressing as how we dress as being a root part of our personal privacy, and is it free from government regulation? And so as we look at this crazy local code from Walnut, California, we get to do a little review of constitutional law. So let's keep going. This brings us to gender and intermediate scrutiny. So remember, if we go back to our con law from law school or the bar exam, or if you're a con law practitioner, you know it, but as a quick re-review of our constitutional law precepts and principles. Government classifications can be subjected to different levels of scrutiny when challenged. And so government classifications based on race, as you may remember, get subjected to strict scrutiny, which require the greatest of reasons, the most narrow tailoring to justify the law. And it's very hard for law to survive strict scrutiny because it's very hard for the government to engage in sort of racial classifications or race-based determinations. The next level down of scrutiny is what is known as intermediate scrutiny, and that's reserved for classifications based on gender and perhaps other things. And then, of course, if it doesn't fall into any of those categories of being strict scrutiny or intermediate scrutiny, laws are subjected to rational basis review. And so the government just simply needs to proffer a rational basis for the law. And the law stands subject to the constitutional challenge under the 14th Amendment or the First Amendment or the like. So here, of course, when we're talking about the Walnut, California code that denies men the right to cross-dress but not women, we see, facially at least, that we could have a gender challenge to the statute, which would be subjected to intermediate scrutiny because the law is discriminating, the city of Walnut's discriminating against men based on their gender in a way that it's not discriminating against women based on their gender. And so intermediate scrutiny is, and this is the Craig versus Bourne 429 U.S. 190, 1976, but it's a very standard proposition of the law. This just happens to be the case I took it from for our review of intermediate scrutiny and gender. Intermediate scrutiny is only invoked when a state or the federal government passes a statute which negatively affects certain protected classes, including gender. To pass intermediate scrutiny, the challenged law must, 1, further an important government interest, and 2, must do so by means that are substantially related to that interest. Now, on one level, if this challenge was brought, what would the city of Walnut say to justify denying the men the right to cross-dress, but not women? It would be tough to get over that intermediate scrutiny test. It's hard to imagine what the important government interest is, and it's hard to conclude how they could have this law in a way that's substantially related to that interest, and they must do so by denying this right. So it would probably fall. But what if the city of Walnut, as we move along and we look at this in a little more detail in terms of our constitutional review of constitutional precepts, what if the city of Walnut said, okay, fine, we're going to fix that issue. We're just going to say no one can cross-dress unless they get that sheriff permit. That would fix the gender issue. What would that do? So let's go to the next slide. This really gets to an interesting question. Is there a fundamental right to freedom of dress? And we can look at this and contemplate this idea by recognizing that dress, one's clothes, can be conceptualized constitutionally as a form of our identity, as a form of our control over our body, over our personal statements that we make, and our personal statements are political statements. They can be communicative efforts, whether it's the famous case from the 1960s, the Cohen case where he wore a button that said F the draft. It could be a political T-shirt or a hat that supports one candidate over another candidate. I mean, personal statements are political statements and are a part of our dress, and dress is used for personal identity reasons. And what level of regulation can the government, federal, state, or local, really do in terms of saying what you can and cannot wear? I mean, can they demand that I wear this suit, tie, and shirt if I go speak at a city council meeting? That's kind of the question that we're talking about here, that kind of an ordinance gets to when you peel back the craziness of the first couple levels and you get down to this root level when we really look at these issues. And so here are a few cases. None on point. Turns out I don't think there's many localities that have those types of laws, and they certainly haven't wound their way into the federal courts for challenge. But there are other cases that have conceptualized and addressed the issue of dress, and it comes up in different circumstances, as we can see here. The first is Hodge versus Lind, 88 F sub 2nd 1234. This comes out of the District of New Mexico in the year 2000. And here you had someone who was wearing a baseball cap backwards and got punished for it under provisions that it was, apparently gang attire, and it looked like gang attire, and you couldn't wear caps backwards, in school or in certain, state buildings and the like. And the court ultimately concluded that there was no rational basis that justified that law's existence to punish the person for simply wearing a baseball cap backwards. And so, at least in that context, that law fell. And it fell in that sense, although it's rational basis review. It wasn't the court saying there is this fundamental right to dress as you want, which is subjected to higher levels of scrutiny, intermediate or strict, right? It didn't hold that, but it did hold there's some right, and even under rational basis, there's no rational basis for the law. So it's sort of a backdoor way of protecting that as a right, or a very important right even. Now, the next case is Gatto versus County of Sonoma, and this comes out of the California State Courts. It's reported at 120 Cal Reporter 550. And this dealt with a situation, and this is in 2002, but it dealt with the situation of the fairs, the county fairs. And this is the County of Sonoma, obviously, but whether the fair could ban clothes that they believed may be disruptive within the fair environment. And so there was a guy who was wearing a vest and it had some sort of gang insignia on it, and he was then ejected from the fair for wearing that vest because they said, you can't wear that vest, you gotta take off the vest or leave the fair, is basically the situation. And he challenged it, and the court concluded that while that can be done in the abstract, the law isn't facially unconstitutional. I mean, there are certain clothes that could be banned given the situation. The court accepted that much. They did hold that here, there was just no justification for doing it to this guy. So again, it's sort of another example of the court's not saying that you can never prescribe clothing requirements, but they keep striking down applications of those dress requirements to people. The third one takes us to Florida. This is a federal court case that wound its way up, and this is DeWeese versus the town of Palm Beach, Florida. And this is from the 11th Circuit in 1987. It's reported at 812 F. 2nd, 1365. And there, at the time, there was a Palm Beach local ordinance that banned shirtless running outside. And, as many of you, if you run outside, especially on hot days in places like California or Florida, for a guy at least, it's nice to run without a shirt. And that shirtless running ordinance, however, enwrapped Mr. DeWeese in some trouble. And so he then challenged that ordinance after getting cited under it. And again, like with the cases of Gatto versus County of Sonoma and Hodge versus Lind, the 11th Circuit concluded that there was no rational basis for that law that denied him his right of personal appearance to not wear a shirt while running if he so choose. And so that's another important case in this area, and I think it kind of gets to this point that I've alluded to, which is, in this area at least, courts use rational basis review, and they found laws invalid under them, but they give these rights varying levels of protection in terms of regulating appearance in certain situations. And so while it may not be deemed a first order fundamental right subjected to higher scrutiny, it's very hard to regulate how people dress. And so I think as you unpackage those laws and apply it to our Walnut City Ordinance Code, not only are you running afoul of rational basis review, probably in terms of that law certainly not surviving rational basis review, you even get into another dimension of constitutional rights and interests, which we've alluded to in earlier parts of this program, that revolve around personal privacy and sort of one's private identity and personhood in terms of wearing the clothes they want. So let's now move from the fundamental right of freedom of dress across various jurisdictions, and we're going to come back to the state of California, and we're now going to deal with the case of the flatulent cows. And you can see here on this headline just some of the headlines taken from different news outlets reported on California's efforts to regulate methane emissions from cows, which sounds crazy even saying methane emissions from cows, but it's probably a more polite way to say it. And there you see some of the headlines. Farmers in California say the law stinks. Cow fart regulations. Holy cow, from Bloomberg. So obviously, such a law by California and such efforts by California can provoke hilarious, crazy headlines that let us talk about this in our Crazy Weird Law Curious Lawyer series. Is it a crazy weird law? Well, let's look at what's going on with the cows in California. The question I'm really raising for all of you is, are a lot of these crazy laws crazy, Or if you unpackage them, is it really in the eye of the beholder? Maybe it's not so crazy. Maybe because of the subject matter, it makes for fantastically funny headlines that make everything sound crazy, but maybe it's not so crazy. Then again, maybe it is, and this is for you to decide. But let's unpackage what's going on in California with our cow methane law. California Senate Bill 1383 was approved by the governor of California in 2016. And this demands that California livestock management operations reduce methane emissions by 40% by the year 2030. And the underlying rationale for this law is obvious. Methane is not good for the environment. And regardless of whoever stands on the broader political issues of climate change, global warming, and the like, nonetheless, it seems everyone agreed in the California legislature, at least, that methane's just not good for the environment. All else being equal, it'd be better to reduce methane. And so this law was then passed, which required analyses to then go underway with regulations that will take effect on January the 1st, 2024. So they haven't taken effect until January 1st, 2024. But they're underway figuring out how to achieve this 40% target by 2030. And so the plans that will then take root in these regulations are twofold as it currently stands. To have mechanisms known as methane digesters, and these are some sort of complex machinery contraption mechanism that probably is worthy of a patent if we're talking about patents again, but have a methane digester that can trap the methane from the cows, capture it, and then turn it into fuel. And so these could be massive sort of operations that sit, the casings that sit over the buildings, the cows are in during the night at least, to help capture methane and then convert it into fuel and do this in a way that's now environmentally safer and better for the environment. The other regulation that currently will go into effect is to figure out ways to alter the diet of a cow to reduce the flatulence of a cow, while at the same time, of course, not damaging, consumers of milk in terms of what it is they may now be consuming if the diet's changed, new ingredients are put in there, or perhaps it'll be bioengineering and some way of engineering certain crops to make a cow less flatulent, but now our milk may have trace elements of that. And so all of that is to be determined down the road, but that is the case of the flatulent cow in California. And so that law, is it crazy, is it not? It's in the eye of the beholder, probably. Time will tell, and California on environmental issues is always and routinely, regularly ahead of other places in terms of progressively legislating these issues. And so who knows, maybe it'll take root, maybe it will work, maybe it won't change milk, and maybe other states will follow suit. We'll see. Now we come to our final segment, and it's the corner of Yellowstone where no law applies. Is that really true? Is there a crime spree zone free from the law in Yellowstone National Park? Well, it turns out there may be. And this comes from a fascinating article by a law professor, Brian Kalt, who has looked at a variety of issues and has come to the conclusion, as you study the Sixth Amendment to the United States Constitution and federal jury citizenry and jurisdiction laws, that there may be a bit of a conundrum in that there may well be a small little section of Yellowstone National Park that sits in Idaho and Montana where you could commit a federal crime free from any prosecution. Now, don't take this as legal advice, because I don't want you to go off camping in that little remote region of Yellowstone National Park, kill someone and think you can get away with it, because I don't think you can, and I don't think it'll ever fly. So this is not legal advice. But it's really fascinating as we look at crazy, weird laws, how on earth this could have come to be, because on its face, the professor's analysis is right, it appears. So let's do a little walk to analyze this through venue and vicinage laws for jurors in trials. And this brings us to Article 3, Section 2 of the Constitution, which says, "The trial of all crimes shall be by jury, and such trial shall be held in the state where the crimes have been committed." So that's our first precept that's important as we build out our stool. You get a jury trial, right, which we all know that's constitutional, and it'll be in the state where the crime was committed. Now, the Sixth Amendment says the jury has to come from the state and the district where the crime is committed. And the district, of course, is the federal overlay for federal cases in terms of the federal districts that exist for regulating behavior in that district. And so under the Sixth Amendment, you have to be put before a jury in the state and district where the crime is committed. And so as you can see, this is getting us into, you can see where it's coming, the conundrum of Yellowstone National Park, because Yellowstone straddles 3 states, Wyoming, Idaho, and Montana. And it's just a sliver of Idaho and a sliver of Montana. But under federal law, all of Yellowstone National Park sits in the District of Wyoming, and that's 28 U.S.C. 131. And so this, let's go to our next slide, gets to the law's absurdity. Do we actually have a situation, we can hypothesize the hypothetical, where you could commit a crime in the state of Idaho, but in the national park of Yellowstone, so that you're in the District of Wyoming? Let's say you go there and you're camping, you're sitting out there, and you shoot a gun illegally, if it's illegal to shoot a gun in Yellowstone. Or, I don't know, you steal some invaluable cactus growing there, if they even grow cactus there, or a plant. Or maybe there's another camper and you get upset and you kill the camper. And so the federal government says, I'm indicting you, and you're going to trial in federal court for this federal crime. And so the question then is, you say as a defendant, okay, I want a jury trial right. And I'm entitled, under those federal precepts, to have a jury in the district and state where the crime occurred. And the district is a District of Wyoming, but the state is the state of Idaho. And so my jury panel gets to be drawn from there. Now, the problem, of course, is that that portion of Idaho is in the federally declared District of Wyoming. And so that little sliver in the District of Wyoming, but the state of Idaho, you'd need a potential jury pool to go be culled from that little portion of Idaho so that the District of Wyoming could prosecute you properly under the Sixth Amendment. So that means the federal judge in the District of Wyoming case could say, great, we'll pull a jury pool from the people living in the portion of the state of Idaho within the District of Wyoming. But it turns out, you guessed it, the population, 0. No one lives there. So you could be indicted and prosecuted. You refuse to waive jury trial, you demand your jury. You cannot get a jury under the Sixth Amendment, and so the case has to be dismissed. And so, ergo, could you get away with a perfect crime there? Well, that is crazy weird laws, and that's the law's absurdity. And that brings us to the crime spree zone question. Because really, that hypothetical is not too far-fetched. I mean, you are, as a defendant, entitled to a jury from the state and district where the crime occurred. You refuse to waive a right to a jury trial, and so no jury can be impaneled, and so really the prosecution has to dismiss and the court has to dismiss it. So that is sort of, in effect, a crime spree zone that's been created because of this bizarre intersection of the Constitution and some federal laws, and just the lack of foresight in terms of thinking about making all of Yellowstone National Park within the District of Wyoming. Now, let me pause right here. Don't take this as legal advice. Don't go to Idaho, or that little portion of Idaho in Yellowstone National Park, and commit a crime. Your conduct may well violate other laws in other jurisdictions as you prepared for and made your way there. So there could be a whole bunch of different ways to frame the crime as not occurring just there. You could also trigger lesser charges that don't require the right to a jury, and so you could be prosecuted under that. And most fundamentally, do we really think that even though the law says this, and it's a very compelling legal argument, that's what the law says, you can't really do anything about the statement in the Constitution in terms of the right to a jury from the state and district. It says what it says. But do we really think, even though it says that, the judges are going to let people get away with crime outright? That's the crime spree zone, that's the crazy law. Now, there are counter-arguments. I mean, the counter-argument, of course, would be the idea that it's, some literal view of the Sixth Amendment and you're being hyper-literal. And I guess the response to that is, yeah, I'm being hyper-literal. That's what the law says. But we all know judges and courts and their ability to argue about being overly literal and finding ways to discredit laws. So the interesting case here is that there's some postscripts that are really worth evaluating as we really analyze crazy laws and think about the craziness of laws and legal regimes and what we should be doing about them. Postscript number 1. This law professor who identified this, he actually tried to get this loophole in the law closed. He literally reached out to all his senators and congressmen in Congress and wrote letters to them and went to them and explained, look, there's this crazy situation where you technically have, like the perfect murder zone You need to just close the loop. It's a simple law. Could it be controversial? Obviously not. One sentence. You tweak one sentence in the law, you'll fix it. Radio silence. No one cared. Now, even this happened after a best-selling author heard about this analysis and wrote a murder mystery novel built around this very idea, thereby proselytizing perhaps to thousands of people that there's this little place in Idaho or Montana where you can go do this and get away with it. Even then, Congress didn't care. They were indifferent. News articles were written from around the world, the BBC, the Associated Press, you name it. No interest in Congress to revisit the law. This actually gets to the flip side of what we were talking about earlier when we talk about crazy, weird laws. On the one hand, we have crazy, weird laws that have been on the books, and legislators, maybe they don't know about it, but they should go do their review and analysis and fix and clear off things that don't make sense. Here's an example of one where it's not a crazy, weird law on the books so much as it is a loophole that exists because of the laws on the books that requires just a new positive law to be written, a sentence. And the inability to get attention to do something that's just so obvious, so it's not controversial, it's not political. Perhaps that's the problem. There's no lobbying for this thing. No one's interested in lobbying for it. So, postscript number 2, the case of United States versus Belderain, because it turns out truth is stranger than fiction. A crime did happen in that portion of Yellowstone National Park that does not sit in the state of Wyoming. Now, it was in the sliver that's in Montana, not Idaho. And Montana actually has a small population that theoretically could get a jury, apparently, although maybe not. But here's what happened. December 2005, the defendant, Michael Belderain, he illegally shot an elk in Montana. Now, because he was standing in the national park when he did it, and he dragged the animal's head, this elk's head, to his truck parked in Yellowstone, he was indicted under federal criminal law in the District of Wyoming, which, remember, has full federal jurisdiction for all criminal behavior that occurs in Yellowstone National Park, even if it is in the state of Montana. Now, he had heard about our Professor Kalt's law review article, and so he and his defense lawyers looked at it and said, wow, that's a great argument. And they made the argument to the judge saying, I object to a trial in Wyoming with a jury pool from Wyoming. I want a jury pool from Montana. Now, it's not even clear if there were enough jurors in that portion of Montana to fill a jury. Maybe there were, maybe there weren't, but there certainly were in Wyoming. So he said, I want my jury to come from Montana where I committed my crime. And the Sixth Amendment says I'm entitled to a jury in the state and district. It's the state of Montana. It's indisputed. And he actually cited Professor Kalt's article and put this before the court. The court, however, held, and held could be generous, the court said, that's an interesting law review article, and it's esoteric, but I'm denying the request because if I were to do this, the Constitution would have created a no man's land, and I just don't like that. And so the defendant was offered a plea deal, and here's what's fascinating, because here's how you know this is an important problem in our law. He got a plea deal, a good plea deal probably for beheading and killing an elk, but he got a plea deal, but as part of his plea deal, he was not allowed to appeal this to the 10th Circuit. Now ask yourself why that is. It's probably because no one wants, the prosecutors at least, don't want the 10th Circuit to get a hold of this and have to issue the obvious ruling, which is you can't do a jury for this guy unless you pull the jury from that area, which would mean in Idaho at least, you could never have a federal criminal prosecution for a crime in the Idaho portion of Yellowstone. So they didn't want it to go up. You would think that now that this has happened and they affirmatively, as a prosecutor's office in the United States Attorney's Office, part of the Department of Justice, were worried about this, maybe now Congress would change the law. No such luck. Radio silence still. So it still remains to be tested, although I'm not encouraging you to test it and it's not legal advice. Don't test it. Here's our conclusions. This is a crazy, weird session, right? As we've walked down this path of laws, it's like going down the yellow brick road into the land of Oz almost, sometimes you probably felt like. One of the conclusions you can come to here is that for those of you who feel overregulated, and regardless of what your politics are, if you feel overregulated, it's really hard to dispute that almost all aspects of our lives really are heavily regulated at the federal level, the state level, and the local level. All areas of the law we found, and we've crossed a lot of them, from sports to the internet to sexual relations, they all have funky, weird laws on the books. But Sometimes the deeper rationales may or may not make sense, as we saw with what at first blush looks funky, our California flatulent cow law, but maybe there's a rationale to that law and it's not as funky and weird and crazy. We also know that there's a particular near obsession by our historical state legislators when it comes to regulating human sexual behavior and all aspects of human sexuality, and that underlies a lot of crazy, weird laws that are on the books. And some crazy situations come arguably from the law itself, but more from the interplay of different legal regimes, where you simply have some states that prohibit possessing sexual toys, whereas the federal government actually, as a matter of federal policy, deems many of them useful and worthy of a patent. I think one of the conclusions that you certainly come to here is that legislators need to clean up the books. They need to get their act together and clean up their books on some of these laws, especially some of the ones that are facially unconstitutional, and reset the deck so that we're all working from a proper playing field. Why? For one very important reason. You remember the little law about the guy in California who got arrested for cutting a shrub? Well, that is the nature of what it means to have laws on the books, because you suddenly give discretion to police and public officials to arrest and indict people, and maybe it doesn't go the distance and it gets kicked, but that person has had to spend money on legal fees, and that person for the rest of their life has to answer yes to a question: have you been arrested for a felony or a crime? Which may not be a fair thing to put someone in. So I think all of this shows that legislators should spend more time cleaning up the books, and we should hope that our prosecutors, if any of you are watching, and people with the discretion to enforce these laws, exercise an extreme amount of caution and thought before flexing those really powerful muscles. Finally, please don't go to Idaho in Yellowstone National Park and commit a crime to test this law. It's not worth it. Thank you for watching today's Curious Lawyer series. Stay tuned. We're always having more fun walks down these off the beaten paths of the legal regime that we all live in. Stay tuned.